The emails were sent to them. They didn't have to read them. But I guarantee you they chose to read them. They chose to read them because he was expressing ideas that are diametrically opposed to what they believe in and what they were trying to teach and what they were trying to do and what they were lobbying about. He was engaged in a political discussion with these people about his religious beliefs, and that speech is protected, totally and completely protected. It has been that way since this country was started. And just because they don't like it doesn't mean, or just because he made some outrageous statements about it, or he made some challenging statements about it, or he said some things that they didn't like, that they found uncomfortable, does not mean that it's constitutional. And what this court has got to decide is whether what he did constitutionally protected speech. And if it is, then this part of the statute is unconstitutional, as the state of North Carolina is trying to do. In one of the cases, Your Honor, is that the concept of freedom of speech and freedom of religious expression and the things that we're talking about here, which are strong convictions that people have. And Your Honor, you've lived in this state. There have been strong convictions. I remember the speaker ban controversy, HB 2, and they've always been controversial. And people are on different sides. And both of those individuals have the right to express themselves as it relates to their political ideals and their religious ideals and say what they want to about that. And what that case said is whether the other side likes it or not, and whether the other side thinks that he ought to be punished. The state of North Carolina cannot punish him unless it is constitutional. And our position is that it's not constitutional here. They weren't a captive audience. This was on the internet, and we all know what's happening on the internet. In fact, Your Honor, I would venture to say that I'm losing more cases because of what people say on the internet than I'm winning. Now, I'm winning some because the people are saying the right things. And it's my position in this case that he had the right to say what he said. He said it. He said it in a way that none of the 5 areas that are unprotected fit. And so the court has got to take that strict scrutiny, whether it's comfortable, whether they like it or not, whether they agree with it. It doesn't make any difference. The state of North Carolina can't punish him for doing something that from the Constitution of this country, from the Bill of Rights, from the time this country began, he has a right to do. Now, I'm sure they're going to argue about, well, these are private citizens. They work at a public university. They're employees at a public university. They were lobbying the legislature on certain issues, especially as related to HB 2. And I submit and say that when they started doing that, they subject themselves for scrutiny by the citizens of this country and by the citizens of this state, for people that disagree with them, to have the opportunity to say to them, I disagree with you, I don't like what you're doing, and you need to stop it. And here's why. And that's what he did. And they didn't like it. They sent him some deceased letter by some officer at the UNC Police Department to stop doing it. And he didn't. He didn't because he has a right to keep saying it. You know, I can go up the street this afternoon and there can be somebody standing on the street holding the sign saying the world's coming to an end tomorrow. And I can go up to him and I can say, you fool, the world ain't coming to an end tomorrow. You know why? Because biblically the following things haven't happened. That is a religious belief. He thinks it's coming to an end. I don't. We both have the right to stand there and talk to each other about it, to have a robust debate about who's right. That's what he was engaging in with these people, a robust debate. They chose to run and hide behind the statute that I submit and say, under the facts of this case, when applied to him and what happened, is totally and completely unconstitutional. I asked the court to read very carefully the Bishop case. It does a very good analysis of what the Supreme Court and the district courts have said about that strict scrutiny and that concept and those ideas and how you do it. And if you do, I believe you'll come to the same conclusion that the court did, that those comments were outrageous. Those comments were very demeaning. Those comments were very disturbing to the individuals that got them. The same type of medium. And this court ruled that that statute, as it applied and to the facts of that case, were unconstitutional because the statute in of itself really tends to restrict the right of free speech to express an opinion on something that is political and religious. And they went so far as to say even sexual. And I asked the court to read the statute carefully because this case carefully, and go back and read that statute. It's quoted in the statute, it's like 14,458 something. But I asked the court to take a really good and careful look at it. Now, I'll sit down and stop, and I will, sometime in the near future, submit a brief. But I won't promise you when it will be because I've got to start a trial tomorrow that I didn't think I was going to have to try.